Hello, everyone, and welcome to Uncivil Law. I hope you are having a good day, and we are here with an update on a copyright case as it relates to fair use. This is the case of Mr. Gray versus Miss Perry over the copyright infringement alleged in the song Dark Horse by Miss Perry, as compared with the musical composition from Mr. Gray in the song Joyful Noise. When we last left the action in this case, Mr. Gray was found to have a legitimate copyright interest in this 8-note ostinato that was purportedly infringed, and Miss Perry was ordered by a jury to pay $2.8 million in copyright infringement damages. At the time, I said that this was probably in line with the law as it was. I said that this was a principally fact question, and the degree to which it does or does not interfere with it is a question of fact, and therefore I thought the jury was probably right. Well, as can sometimes happen in these things change, not the least of which is that there was a precedential decision from the Ninth Circuit Court of Appeals that came down in the interim. So the law changed. The law changed since the jury reached its verdict. The law changed. So when I said, well, according to the law, this seems to be okay, well, the law changed in the interim. It changed in an unrelated case called Michael Skidmore versus Led Zeppelin over the purported infringement of Stairway to Heaven. And in this somewhat lengthy opinion from the Ninth Circuit Court of Appeals, which of course California is in, they said that essentially in so many words that the notes in Stairway to Heaven, that even if they were copied, were not copyrightable. And so we are going to potentially get into that issue. So the law changed. All right. So then the trial court, which still had issue over this, or still had jurisdiction over this, one of the things that the opposing side did was ask for a motion as a matter of law, judgment as a matter of law, sometimes called JNOV, judgment non-observational law, JNOV, judgment notwithstanding the law, or a new trial. So the side that lost asked the trial judge, said, hey, we want a new trial. And while the trial judge was considering this, the Ninth Circuit Court of Appeals was considering the Led Zeppelin case. And so the trial judge, not being an idiot, decided to hold on to his decision on the issue of it while that case was percolating, because it was probably going to be relevant. And then on March 6th, it came down from the Ninth Circuit. And on March 16th, 10 days later, the judge reached a decision saying that, this was not infringement as a matter of law. And he may be citing to the Ninth Circuit Court of Appeals. I imagine it's going to come up. We are going to see, because I haven't read this before. So we're going to read this decision from the trial judge. So just remember, in terms of the factual background, just so we're on the same page on terms of factual background, there was a trial. There was a jury verdict. The jury did find an award against Miss Perry. And then the judge was asked for a judgment as a matter of law, which is one of the things you can ask for. And so the trial judge overturned the jury's verdict because it was still at trial. And they said, well, we're going to consider it and we're going to do this. So the trial judge essentially overruled, well, either themselves or the jury, depending on your point of view. And we are going to read this and see what the judge has to say. This is a 32-page decision. We are probably going to read all of it, and we will offer some commentary along the way. This copyright infringement concerns the allegations that an 8-note ostinato from defendant's song Dark Horse infringes upon plaintiff's copyright in a musical composition of the 8-note ostinato in their song Joyful Noise. Following a jury trial, the court found the plaintiffs awarded damages and the court entered judgment. Now, before the court, are defendants' renewed motions for judgment as a matter of law or in the alternative for a new trial, as well as plaintiffs' motions for pre-judgment interest on damages. Plaintiff Marcus Gray, otherwise known as Flame, Emmanuel Lambert, and Chaik Okwa, there's no way I got that right, filed the operative third amended complaint, which just says this is the one that's guiding us. Operative just means the one that's in place. On November the 1st, 2016, naming defendant Catherine Elizabeth Hudson, otherwise known as Katy Perry, Jordan Hudson, otherwise known as Josie J., Lucas Gottwald, otherwise known as Dr. Luke, Sarah Thursa Hudson, Carl Martin Sandberg, otherwise known as Max Martin, Henry Russell Walter, otherwise known as Circuit, Kaz Money, Capitol Records, Katy Perry Inc., cute, UMG Recordings, Universal Music Group, WB Music Corp, BMG Rights Management, and Cobalt Music Publishing. So we're suing just like everybody. Okay. In substance, plaintiff complains the instrumental beat of the ostinato and joyful noise is a protectable original expression, and defendants had access to and copied that protectable expression when they composed the allegedly infringing ostinato for their song Dark Horse. So, because I am so well renowned for my singing abilities on this channel, I will give my best impression of it. Do 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 do. That's the only time we're going to be doing this today. But on the plus side, YouTube Music is unlikely to catch that as infringing because it was so bad. There's no way that their algorithm can say that was matching. I've caught on to you, YouTube. The court held a jury trial from July the 17th, 2019 through August the 1st, 2019. The jury entered verdicts finding defendants liable to plaintiffs for copyright infringement and awarding plaintiff $2.8 million in damages. The court entered judgment in favor of plaintiffs on September the 11th, 2019. Defendants filed instant renewed motion for judgment as a matter of law or in the alternative for a new trial on October the 9th, 2019. So they filed a motion for a judgment as a matter of law after the verdict was over, and it's a renewed motion because I'm sure they asked for it as soon as the plaintiff was done with their case, because that's typical. It's very typical. As soon as the plaintiff is done and says, that's the end of my case, it's very typical for the defense to say, I want a judgment as a matter of law. So this is a renewed motion because we're asking for it again. Plaintiff filed opposition on November the 20th. Defendant filed reply on December the 27th. In addition to these supplemental submissions from the parties, a group of musicologists submitted amicus briefs in support of defendant's motion for renewed judgment on January the 9th, 2020. Plaintiffs, meanwhile, filed a motion for award of prejudgment interest on October the 10th, 2019. Defendant Katy Perry filed opposition on November the 20th. Perry also joined in an opposition filed by the balance of defendants, the rest of the defendants, which was filed on the same day. Plaintiff filed a reply on December the 27th. Having reviewed the trial record, plaintiff submissions, and submissions from the amici, friends of the court finds and concludes as follows. The law. Judgment as a matter of law. Judgment as a matter of law, which, basically judgment as a matter of law, the easiest way to think about this is that no matter what the facts are, or given the facts as represented by the plaintiff, that there can only be one outcome. So you would see this in like a motion to dismiss, you'd see this in a motion for summary judgment, and you can see it in a motion for a directed verdict, or in a motion for judgment notwithstanding the trial court decision, or the jury's decision. All those things basically is a matter of law. So, assuming facts or given facts as found by a jury or whatever, that, given the operative facts, the law requires a particular result, right? This is not a factual dispute anymore. This is a legal dispute. One of the things, you don't need jury for the law. You need courts for the law. You need juries for facts. Well, we did that. We did the fact thing. So we know what the facts are because the jury told us. But now we get to do the law thing because that's what courts do. So now we're going to do the law thing. Judgment as a matter of law is appropriate when a party has been fully heard on an issue during jury trial and a court finds a reasonable jury would not have legally sufficient evidentiary basis to find for the party on issue. So one of the things they're saying here is that one of the bases for judgment as a matter of law is if the jury just plain screwed it up. If the jury came up with a finding that is not supportable, then the one of the things the court can do is set it aside. Now, they can't do that in the case of a criminal acquittal. They can't set aside a criminal acquittal. They can set aside a criminal conviction. And in a civil case, they can do it either way. So if it's required, it's required. If a court does not grant a motion for summary judgment as a matter of law pursuant to one rule, a party may file for the renewed judgment after the trial, which makes sense. It is well settled the standard for judgment as a matter of law is the same for summary judgment, which is why I compared them like 2 minutes ago in this explanation, right? When I said, whether we call it dismissal, summary judgment, whatever, right? It's basically the same thing. No matter what the facts are, or given the facts, or assumed the facts, whatever the case may be, depending on what stage we are, does the result come out one way. The prior denial of summary judgment does not preclude a district court from later granting judgment as a matter of law pursuant to Rule 50 because the latter tests the sufficiency actually provided at trial. And that makes sense too. That makes sense because in a motion for summary judgment, we look at like all the evidence that is on the record at that point, like all the things that are available. But, you didn't necessarily present all those things at trial. You might have presented different things for potentially a lot of strategic reasons or tactical reasons. So the evidence on the record at the point of summary judgment is not the same either way as this evidence that actually happened in trial. So now we have to look not at the evidence as it existed at the point of summary judgment, but the evidence as it existed at the point of the end of trial. Well, you had a whole bunch of evidence, but what did you actually offer? Well, this is what actually exists now. That you had other evidence in waiting. Well, it's too late for that now. Too bad, so sad. So, and we just look to what you actually presented. So good stuff. Judgment as a matter of law is accordingly appropriate when there's no genuine dispute as to any material fact and the movement is entitled to judgment as a matter of law, which, given that we just had a jury trial, the facts have been established by the jury. So that's the reality now. Thanks. The moving party bears the initial burden of identifying relevant portions of the trial record that demonstrate the absence of fact or facts necessary of one or more essential elements of the claim. So basically, in any given lawsuit, in any given court case, criminal or civil, right, you have elements that you have to prove. That you did blah, 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 blah. And if there's not enough evidence for a particular element, one of those things, well, you had to show that. So you have to look to each element of every charge. Makes sense. If the moving party meets its initial burden, the opposing party must then set out specific facts on which a reasonable jury could have relied in order to reach a verdict. In light of the facts presented by the non-moving party, along with any undisputed facts, the court must then decide to whether the moving party is entitled to a judgment as a matter of law. The court must view the trial evidence in a light most favorable to the non-moving party, and if conflicting evidence may be drawn, the case must go to the jury. We do prefer the jury, right? So, like, all else being equal, we had a jury verdict, and so, we're going to rely on them. That is kind of the point of having juries. So, yes. In entertaining a motion for judgment as a matter of law, the court should review all evidence of record. In doing so, however, the court must draw all reasonable inferences in favor of the non-moving party and may not make credibility determinations or weigh the evidence. That would be something for a jury to do. So, one of the things a court should not do in doing this is try to weigh or evaluate. A jury in the face of conflicting evidence gets to weight the evidence and consider credibility of the evidence. It's one of the things they get to do. So, 10 people testified, one said one thing and 9 said the other. Who should win? Well, it depends on, at least in part, how credible you find them respectively. And, how you weight them respectively. Does the 1 win or does the 9 win? Well, that's what juries are for. So a trial judge is not doing this. That's what a jury is for. We already did that. So we're not going to weight them or consider credibility. We're just going to look at it in the light most favorable. The jury has the right to look at it in a light not most favorable. That's what juries are for. Juries do not have to look at it in the best possible light. It is specifically their job, in fact, to not look at it in the most favorable light. Their job is to figure it out in the light of reality. But we're trying to do something as a judgment as a matter of law, so we're superseding the jury. So since we're superseding the jury, we'll look at it in the most favorable light possible. Because we want to give the jury every deference, because that's why we have juries. Credibility determinants, weighting of evidence, and drawing legitimate inferences are jury functions, not those of a judge. Yep. Thus, although the court should review the record as a whole, it must disregard all evidence favorable to the moving party that a jury is not required to believe. Right. So we're looking at, again, like we have to consider the respective roles of people and the stages that they're in. The jury, when they're waiving things, gets to look at all the evidence from all the people and weigh them in any consideration that they deem fit. Anything that's in any sort of scope or reasonable is within their discretion. They get a pretty wide latitude as to reasonable too, because there's 12 of them, and that's the entire point we have them. But in judgment as a matter of law, we're looking, well, we're taking this away from a jury, so therefore we're going to ignore all the evidence that would go the other way. We're just going to look at the evidence that is favorable to you. That was submitted at the jury. So we're just going to look at everything everything that Flame offered. We're going to look at everything Flame offered. Katy, I'm sure you had some interesting evidence, and you said it had some interesting testimony and stuff to offer, but at this particular moment in time, we don't care. We don't care about all that interesting evidence, Katy. We don't care about all that interesting testimony, Katy. Not our issue. We're just going to look and see what Flame said. Hey, Flame, what do you have to say? Everything you say is true. Should it come out one way or another? And, that's what we're trying to determine. So does Flame win if, he's the only one speaking in this trial? That's what we're trying to figure out, basically. A court may grant a new trial if jury's verdict is against the clear weight of the evidence. In considering such a federal rule of civil procedure 59 motion, unlike a motion for judgment, a court may weigh the evidence and assess credibility and need not view the evidence from the perspective most favorable. If, having given full consideration of the jury's finding, a judge on the entire evidence is left with a definitive and firm conviction a mistake has been made, it's expected they'll be granted new. Hello, does anyone hear me? Hopefully. I don't know. Is this working? One can only hope. Yeah. All right. Am I back? Yes, I am. Very good. Yes, OBS completely locked up. OBS completely locked up, so we are back. All right, great. OBS completely locked up. Sorry about that. OBS decided to stop working. All right. I don't know exactly where we left off, so we'll just start over here. A court may grant a new trial if the jury's verdict is against clear weight of the evidence. In considering such a federal rule of civil procedure, unlike a judgment for matter of law, a court may weigh evidence and assess credibility and need not view the evidence from the perspective most favorable to the prevailing party. If the court determines that damages is excessive, it may grant a judgment for new trial or deny the motion contingent upon accepting a remitter, which is basically just a reduction. Yeah. The district court may grant a new trial, even though substantial evidence supports the jury's verdict. So in a issue of a new trial, the judge may consider the relative weight of the evidence. So if the court feels that the jury just pooched it given the available evidence, even though they could have, like, in some theoretical world reached it, if they feel like it's against the great weight, they can issue a new trial. Because juries can go off the rails. So they can issue a new trial. So that's the standard for a new trial. You get to look at everything and see what's happening. All right, prejudgment interest. Prejudgment interest is available under the Copyright Act in discretion of district court in situations of undisputed copyright infringement to discourage needless delay and compensate copyright holder for the first time it is deprived of lost profits or license fees. Unlike claims for prejudgment interest that arise under state law, federal law does not require denial of prejudgment interest just because a claim was not liquidated. Federal claims clearly have latitude to award prejudgment interest in cases under the patent, copyright, antitrust, and tax laws where claims are not liquidated. So basically, long story short, you can award interest. In vigorously contested cases, however, a district court may properly decline to impose interest. If prejudgment interest is granted, it should be awarded as an element of compensation and not as penalty. Fine. To prove copyright infringement, a plaintiff must establish ownership of a valid copyright and copying of constituent elements of the work that are original. So you have to have a valid copyright, and you have to copy the elements that are original to that work, which can get into one very complicated analysis. Very super complicated, trying to figure out what that is. That'll make your brain hurt. The sole issue at trial concerned the second element, whether defendant's ostinato 2 in Dark Horse, infringes on plaintiff's ostinato in Joyful Noise by copying constituent elements of plaintiff's ostinato that are original. This kind of copy can be proved by either with direct evidence defendant actually copied the work or showing defendant had access to the work and that they're substantially similar. Plaintiffs only assert copying pursuant to the latter method of proof, substantial similarity, and access. Okay. Substantial similarity is determined from a two-part test of extrinsic similarity and intrinsic similarity. The extrinsic test raises a question of law that may be decided as a matter of law by the court. A plaintiff who cannot satisfy the extrinsic test need not prevail on the copyright. The extrinsic test requires the plaintiff identify concrete elements based on objective criteria that the two works are similar. There are two steps to the analysis. The court identifies protected elements of plaintiff's work and then determines whether the protected elements are objectively similar to corresponding elements of the alleged work. A collection of otherwise unprotected elements may be found for copyright protection under extrinsic test, but only if the elements are numerous enough and their selection and arrangement original enough that combination constitutes an original work. All right, so that basically what that says is that you can achieve originality either by having originality or by having non-originality, but so much of it in a particular combination it becomes original, right? So this is like basically more than the sum of its parts, basically. At some point, when you arrange enough stuff that's in the public domain together, like each thing that's in the public domain is not copyrighted. That would be what it means to be in the public domain, right? So if you take something in the public domain and put it into a copyrighted work, it doesn't become copyrighted because it's in the public domain. That wouldn't make any sense. However, if you string enough things from the public domain together in some sort of unique combination, although the original public domain work doesn't become copyrighted, your unique combination does because your unique combination is new. So that's basically what that's saying. When you put enough things together, it becomes more than the sum of its parts. Which kind of makes sense when you're talking about copyright because, if that weren't the case, you'd have a real trouble copyrighting like literally anything because like everything broken down enough is not original. Right? So it's only by combination that it becomes original. So, yeah, I mean, if you look to every element, figure out whether it's copyrighted, then like there would never be anything copyrighted ever again. Not quite what the law had in mind. For a plaintiff that seeks to apply this theory of protection to works where there's a narrower range of available creative choices, defendant work would need to be virtually identical to plaintiff's work in order to be substantially similar. So if we're in an artistic form where like all you can do essentially is put together like cobbles of public domain work or unprotected work, then we could only find infringement for identicality or virtual identicality because like there's only so many combinations to be had, right? So, the idea that someone would trip over someone else is like, well, if we look at too broadly, it's going to happen all the time. So it has to be the same thing, basically. So that makes sense. The Ninth Circuit has at times described this result as a thin copyright. Infringement claims involve combinations of individually unprotected elements are subject to analysis. Only after the extrinsic test is satisfied does the fact finder, in this case the jury, reach and apply the intrinsic test. I'm not sure why the words fact finder are in quote marks. I can only assume that they're literally quoting from the case of Malibu Textiles. I can only assume it's a quote marks because it's a quote from the case, because otherwise it's weird. This test raises a question of fact that asks whether the ordinary reasonable person would find the total concept and feel of the works to be substantially similar. A plaintiff that proves substantial similarity, must still prove access. Proof of access requires an opportunity to view or copy the work. To prove access, a plaintiff must show a reasonable possibility, not a mere bare possibility, the alleged infringer has a chance to view the work. When there's no direct evidence of access, circumstantial evidence can be used by establishing a chain of events linking the plaintiff's work and defendant's access, or showing the plaintiff's work has been widely disseminated. Plaintiffs argue only the latter type of circumstantial access, which again makes sense because to show the chain, right, is kind of hard, but to show like widely distributed is easy enough. And then you get into what does that mean, and maybe the court will get into it, but yeah. Defendants move for judgment as a matter of law at every step in the analysis. Good for them, I suppose. In addition, defendants contend that they are entitled to judgment as a matter of law on a series of other defenses and damages issues. At minimum, defendants argue the court should exercise discretion to weigh the evidence and order a new trial. The court answers each of these arguments in turn. Plaintiff's theory of copying requires them to prove substantial similarity and analysis. Defendants argue plaintiff failed to present evidence a reasonable jury could find either. That really feels like a jury question to me, right? That feels really like a jury question to me. So I would be slightly surprised if this is the basis on which the court is going to overturn it. It's like these feels like jury questions, and we had a jury. So if the basis for overturning it is this, I'll be a little bit surprised. Let's find out if I'm surprised or not. Defendants argue plaintiffs failed to establish substantial similarity. They advance arguments under both extrinsic, which present questions of law, and intrinsic, which requires questions of fact. The extrinsic test requires the court to determine whether any elements of ostinato and joyful noise are protected and objectively similar to the corresponding and allegedly infringing work. This test is critical because copyright law does not forbid all copying, only illicit copying of protected works. If plaintiffs cannot satisfy the extrinsic test for any reason, the inquiry ends and defendants will be entitled to judgment. The initial inquiry is whether any elements of the ostinato and joyful noise are individually protected, and if not, whether the unprotected elements that make up the ostinato, taken in combination, are nevertheless entitled. Well, this does sound like the basis the court is going to do it, so yeah, I guess I'm going to be surprised. Okay. Although there's generally a low bar for originality, it's pretty low, yes. Given the limited number of notes and chords available, and because common themes frequently reappear in compositions, many, if not most, of the elements that appear in copyrighted and popular music are not individually protectable. C. Nimmer on copyrights. Nimmer on copyrights is one of the great texts on copyright law. If you want to know about copyright law, I'd say get a copy of Nimmer on copyrights, but first of all, it's really expensive, and second of all, it's like 5,000 pages because it covers everything. But yeah, if you're interested in copyright law, Nimmer on copyrights is an excellent place to start and probably end. It's pretty comprehensive. In the field of popular songs, many, if not most, of compositions bear some similarity. Music perhaps more than any other work borrows and must necessarily borrow, uses as much as what's well known and known before. Not sure about that, but okay. For this reason, courts in musical copyright cases have significant obligation to balance between the First Amendment and the Copyright Act. To encourage others to build freely upon the ideas and information covered by the work, and at the same time motivate creative activity by carefully limiting the scope of copyright protection to truly original work. Musical elements that are common or trite, such as the long, short, long rhythm, chord progression, certain tempos, recurring vocal phrases, repeated hook phrases, or the alternating emphasis of strong and weak bass, syncopation, the use of tritones. Well, eat your heart out, Adam Neely. Eat your heart out, Adam Neely, man. You've got your video coverage. You got videos now for days. You got videos covered for days where you have to explain this musically to everyone, including myself. So Adam Neely, eat your heart out. You got this covered, man. I don't know what any of these things mean. I'm sure you're going to be telling us in great detail. I look forward to that. Or the use of base musical devices in different manners, and accordingly not protectable. Nor are other elements ubiquitous in popular music like rhythms, glissinados, I have no idea what that is, chants, the use of horns, or jingling or pulsing synthesizer elements entitled to protection. These building blocks belong in the public domain and cannot be exclusively appropriated by a particular author, citing Led Zeppelin, the case that just happened 10 days ago. So sometimes I really love the law. And this is like one of those times where I really love the law. It's like, the law before was a little different. And now we just have a brand new law. It happened 10 days ago. It's the law now, so I'm now going to discuss it, in my opinion. That's it. What can you do? It's the law now. holding commonplace elements that are firmly rooted in a genre's tradition are not copyrightable as a matter of law, and concluding the jury was properly instructed that descending chromatic scales, arpeggios, or a short sequence of three notes are common musical elements. At trial, plaintiff presented expert testimony of musicologist Dr. Todd Decker. There are 5 or 6 protectable elements in Joyful News, ostinato, which defendant allegedly copied. The length of the ostinato is similar, 8 notes. The rhythm of the ostinato is similar. The melodic content, the scale degrees present. The melodic shape, so the way the melody moves through musical space, similar. The timbre or quality and color of the sound is similar. The use of placement in the material, the ostinato, is musical space in the recording of the mix is also similar. So that's 5 or 6 points of similarity between the two ostinatos, which incidentally was one of the reasons when I discussed this case the first time around was why I said, I think this is probably right when the jury found the infringement. And I felt, I felt like Adam Neely might have been being a little bit disingenuous. I don't mean that necessarily intentionally, but a little bit unfair maybe is a better word for it. I thought he was being a little bit unfair to the other side, where it's like, it's these 6 things in this particular combination that reach a point of originality. I felt like, well, okay, that seems like a plausible contention to me. And so maybe the trial judge is about to tell me why it's not a plausible contention. But it was 2 months ago. The law changed on me. So, hey, what can you do? In their opposition papers, plaintiffs claim that 5 or 6 of these elements are actually 9 separate elements. A melody built into a minor mode, a phrase length of 8 notes, a pitch sequence beginning with 3 3 3 3 2 2. A similar resolution of both phrases, a rhythm of 8 notes, a square and even rhythm. Okay. The structural use of the phrase as an ostinato, the timbre of the instrumentation, and the notable empty and sparse texture of the composition. I'll take your word for it, but this does sound plausible to me. It does sound plausible. Amici musicologists, meanwhile, contend Dr. Decker's testimony at most identifies 5 allegedly protected elements. A pitch sequence of scale degrees 3 3 3 3 2 2, the temporal space of the notes, timbre in the form of pingy synthesizer sound, a purported phase length of 8 notes, and placement of the ostinato in the recording mix. Okay. Jan says 8 notes, so way too short to be an original. Well, again, Jan, this is going to be a point where I'm potentially going to disagree, at least as to that aspect, and maybe I'll agree with you later because the court is about to explain how the law changed. So maybe I'll agree with you later in this very stream. But at this particular moment in time, I disagree that that's the right answer because it's not just 8 notes, right? That's the issue. It's not just the 8 notes. It's 8 notes in the context of all this other stuff that they just said. And the question is all that stuff in combination protectable? And if you had asked me before, and, people did, and I did give an opinion on it, I said, yeah, this probably makes sense because, in this complete combination, sure, that makes sense. And so the judge is about to tell me, I guess, why I was wrong, which is fine, If I'm wrong, I'm wrong. And the judge persuades me, then I'll say, this is right now. So we'll see. I thought, okay, that makes sense. Let's see if why I'm wrong. Maybe the judge will tell me. Defendant's opening brief addresses the elements that Dr. Decker set forth in the passage, but also in his reply addresses the 9 elements set up forth. In fact, defendants argue where their elements are 5, 6, or 9, none of them individually can be accorded copyright protection as a matter of law. Well, I would agree to that. I'd agree to that. I would agree with defendants there. Defendants argue that, and I would agree, whether the elements are 5, 6, or 9, none of them individually can be accorded copyright protection. That I would agree with. But that wasn't the plaintiff's argument, nor was it how the jury was instructed, nor what did seem to be the rationale of the decision. So yes, individually, they're not protected, but that's not the issue, is it? Where is it the issue? We'll find out. The court agrees that the uncontroverted evidence points only to one conclusion. None of the individual elements are individually protectable. I don't disagree with that. It's plaintiff's burden to establish the protected elements of their infringed work. Dr. Decker did not provide testimony that each of the elements he identified are individual originally. Okay, that's not the issue. To the contrary, he testified not one single element caused him to determine the works are substantially similar. I don't disagree. Any single one of the elements would not have been enough. I agree. It's a combination that supports that conclusion. I agree with that too. So I agree with the expert. That seems logical. It seems right to me. All right. Plaintiff contend that notwithstanding what Dr. Decker said, he did not expressly concede each of the elements were unremarkable or commonplace. Okay, I think that's a fair way to characterize it. That's not exactly what he said. It's not the way I read that. Okay. The clear, if indeed only implication of the testimony is if two ostinatos are similar, is reasonable only as a result of the arrangement elements within the ostinatos, not a similarity between the individual elements themselves. Yes, I agree with that. It is their combination. It is their combination as a collective whole, like Power Rangers or something. Each one of them is useless. Actually, Captain Planet is a better example of this point. So I'm going to switch to Captain Planet. It's like Captain Planet. Each one of them is completely useless by themselves. But with their powers combined, I am Captain Planet. So yes, sure. The 5 elements or 6 elements or 9 elements by themselves, pointless. But, together makes a protectable thing. That seems plausible to me. Plaintiff's burden to present evidence that establishes the protectability of each element is not met when their own expert provides testimony that assumes the opposite. Okay, I agree with that. I'm troubled by the way the court is phrasing that, though. The way the court phrases that causes me like, uh-oh. I agree with it. It's like denotation and connotation, right? I agree with it on denotation, but the way I'm reading it in connotation, I'm like, the court seems like it's about to make a mistake. So let's see if I'm, if my forewarning senses are correct. Dr. Decker concedes in substance that several of the originally individualized elements of Plante's work are not original. With respect to the phrase length, Dr. Decker testifies it's characteristic for a phrase like this to last 8 beats. With respect to the beginning pitch sequence of 3-3-3-3-2-2, Dr. Decker testified the repeating scale degree of 3 that Lear resolves as a technique for building up tension that wants to be released. And when such tension is released in a song with a strong beat like Joyful Noise, it's released into 2. With respect to the way Joyful Noise ostinato resolves from 3 to 2 to 1, Dr. Decker's testified that scale degrees have tendencies in popular music such that, to make a pleasant sound, 3 wants to go down to 2, and 2 desperately wants to go down to 1 because 1 is our home note. I have watched just enough Adam Neely to be like vaguely competent. Well, competent's probably too strong. Vaguely aware of what this is talking about. And this sounds plausible. So thank you, Adam Neely, for helping me massively on my music education. Which indicates the way ostinato resolves is not so much original as necessary. With respect to Joyful Noise, ostinato, square, and even rhythm, Dr. testifies this is relatively simplistic rhythmic choice, and even agree no composer is entitled to monopoly on the rhythm of each 8 even quarter notes. With respect to ostinato's pingy synthesized timbre, Dr. Decker testified that it's essentially commonplace, since it would be very difficult to monopolize. And with respect to development of these phrases as an ostinato as opposed to another musical device, Dr. Decker testifies that ostinatos are commonly used musical devices in countless musical compositions. This is, at least for me, like a difference of denotation and connotation. Like every one of these statements, I agree with in denotation. I agree with the words that are used on their literal form. But to my lawyer mind, it is building in a story way or in a musical way, right? And I bet that there's lots of overlap between how story is told and how music is told, right? That there's certain like ways that things are done and resolved and tension points and all the rest. So there's another potential video for Adam Neely, how story as such and music as such are similar in terms of, how points can conflict and resolution. It would be an interesting video. All right. So it's like, well, I don't know that much about music. I did play a musical instrument in high school, so I got that going for me. So I used to be able to read music at one point, not so much at this point. But you know, this is all reading to me in a way where I'm like, uh-oh. This seems like it's headed into the wrong place. It seems like the court is about to make a mistake. It's like everything you're saying here is true, but uh-oh. This is leading to a conclusion where I'm like, I'm not so sure. Let's read on. Let's find out. In fact, the 9 individual elements the plaintiff identify in their opposition are precisely the kind of commonplace elements courts have routinely denied copyright protection, at least standing alone. Okay, at least standing alone. All right, I'm slightly comforted. I'm slightly comforted by by those 4 words. At least standing alone, because to me that is a principal issue here. That's a principal issue. That was what I'm scared about. It's like, the court is doing what it shouldn't be doing. It's looking at this piecemeal. Well, it shouldn't be looking at this piecemeal. It should be looking at combination. But now it says at least standing alone. I'm like, okay, whew. Maybe this will be okay. All right, so that helped me feel a lot better. First, the key or scale which a melody is composed is not protectable. Concluding that a key of A major is non-protectable music element that is not copyrightable. Second, plaintiff concede the length of 8 notes is not independently protectable. I'm not sure a length of any particular notes is copyrightable in and of itself, but we could have a debate. Third, a pitch sequence like a chord projection is not entitled to copyright protection. Fourth, because of the way the joyful noise ostinato resolves is determined by rules of consonance common in popular music, is not the type of musical element that's protectable as a matter of law. Fifth, plaintiffs concede that a rhythm of 8 notes is commonplace. Sixth, even an evenly simplificated rhythm, standing alone is also not a protectable element. Seventh, because an ostinato is a basic musical device that is common in popular music, the use of an ostinato is a given composition, standing alone is not protectable. Eighth, even assuming the pingy synthesized timbre of an ostinato and joyful noise is part of the musical composition, not the sound recording or performance. I'm not 100% sure what difference it would make. I suppose it makes a difference in terms of like what exactly we're suing over like the actual composition versus the actual performance. That would be an interesting legal question, but we don't need to resolve that right now. Even assuming the pingy synthesized timbre of an ostinato and joyful noise is part of a musical composition, not the sound recording or performance, a synthesized timbre is a commonplace element of contemporary popular music that's not protectable. And ninth, assuming a composition's texture is a part of the composition, not a recording, a composition's texture, which according to Dr. Decker refers to the way a composition is mixed to reveal different elements of sound in its absence, is an inherent feature of any kind of music. Yeah. Can I recap the case, please? Well, there was a piece of music called Joyful Noise by an artist called Flame, which came first. And then there was a piece of music called Dark Horse by Katy Perry, which came second. And Katy Perry's music used a similar set of sounding notes to the original of Joyful Noise, and they found to be infringing. So that is the underlying issue in short. All right. That's the case. I don't know that it's possible for me to give you a summary of the case that gives you enough information to independently evaluate it, because we're getting into like the actual noise. I suppose I could play the 2 sound samples next to each other though. Maybe I can find that actually. Hold on. Let's see if I can actually find the 2 sound notes by themselves. And so I'll put that in there. This is fair use because I'm using it as part of a material discussion. So don't at me, Katy Perry or Juicy or Flame or any of you guys. All right. This is most decidedly fair use. I'm using it as part of a contemporaneous discussion as to your lawsuit. Eat me. Let's see if I can find it in a way that like I don't have to scroll through 8,000 things of video to find it. All right. This looks like it might be promising. All right, fair use. Let's do this thing.
It may surprise you that Katy Perry's Dark Horse is 6 years old. In 2013, the pop hit.
See, this is what I don't want. I don't want people talking over it. I just want to listen to the damn thing so we can hear it. I don't want anyone talking. I just want to hear it so we can hear the noise. So we're
beat in question was the
no. Okay, here we go.
next. Now, let's hear. Now, let's hear the two together.
Jesus Christ at 33, but after days reappeared. Jesus Christ anointed one ascended in the ear.
All right, you get the point, right? You've heard both of them. They sound kind of similar. The question is, does it copyright it or whatever? Yeah, eat me. Eat me, copyright people everywhere. That's fair use. Don't at me. The court's inquiry, however, does not end there. Plaintiff may still prove infringement of the osonota if they can demonstrate it's comprised of a protectable combination of otherwise unprotectable elements. Yes. Divided States of America, copyright does not have to be good to get copyright. So, good is not part of the copyright evaluation. Thank you. Plaintiffs may still prove infringement if they can demonstrate the combination. Yes, that is the material issue for me. Those elements must be numerous enough and their selection and arrangement original enough to warrant protection as original work of authorship. Since the selection and arrangement of copyright protects the particular way in which the artistic elements form a coherent pattern, synthesis, or design, is not enough to assert a combination of unprotected elements without explaining how these elements are particularly selected and arranged. Citing Led Zeppelin. The case that just was decided. Yeah, the case that was just decided. I didn't even see the Led Zeppelin when I first went, because like that is a change in the law, right? I was like, I don't know about that. When I first saw that, I was like, I don't know about that. And then I saw the citation. So in case you were wondering what was going through my mind when I was reading that, it's like, since an arrangement copyrights the particular way is not enough to assert a combination of unprotectable elements without explaining how these elements are particularly selected. Now, up until that moment, I had not read the words Led Zeppelin. So up until that moment, what was going through my mind is, I'm not so sure. Because normally in copyright law, we don't ask questions like, how did you come up with the thing? Or what was your inspiration? Or what was your motivation? Or things like that. We don't ask questions like that in copyright law. We don't ask like what was behind the originality of it. Because like, so we don't ask those questions. And so I was like, I don't know, man. I don't know if that's the right standard because, I mean, up to and including a person just randomly banging around on their keyboard, if they come up with a copyrightable thing, even if we can prove that like they were using a group of otherwise unprotectable elements, the composition, sweat of the brow is not part of the copyright analysis. We don't care how hard you worked, one way or the other. So we don't care like how hard it is. We don't care if you wrote the song on the back of a napkin in 15 minutes, which has happened, or like the exact opposite of that, which has happened. We don't ask those kinds of questions. So when I see here a selection of arrangement protects a particular way is enough to assert a combination of unprotectable elements without explaining, I'm like, that doesn't sound right. That doesn't sound right as a statement of law. That was what I was thinking. And then I read the words Led Zeppelin. And I was like, oh. The law just changed. This is new law. This right here is new law. That's why I'm saying to myself, oh, that doesn't sound right. Because, 11 days ago, it wasn't right. But now it's right because the case just came down that just said that. So that's the law now. But if you're wondering where, I was breaking down as a lawyer a little bit, I was breaking down on this because I'm like, that doesn't seem right. But apparently it is right because the law just changed. Okay. In considering the issue, the court is guided by relatively little precedent. Acknowledging extrinsic test provides an awkward framework to provide copyright work like music, and no one magical combination will automatically substantiate a musical infringement suit. Each allegation of infringement is unique in the musical context and must be assessed ad hoc, which basically means we're making it up as we go, which is always super wonderful in law when we just are like, we are literally making it up on the fly. That's good. To determine whether various compositional elements of plaintiff's ostinato were entitled to sort of copyright protection, the court reviews the relevant precedent. Isn't ad hoc a fallacy? That's post hoc, not ad hoc. Beginning with perhaps the most notable case that found a protectable combination of otherwise unprotectable musical elements, and Three Boys, the Ninth Circuit affirmed a finding of copyright protection based on combination of 5 otherwise unprotectable elements: the title hook phrase, including the lyric rhythm and pitch, the shifted cadence, the instrumental fingers, the voice and chorus relationship, and the fade ending. Three Boys concerned whether Michael Barden's 1991 song, Love is a Wonderful Thing, in its entirety infringed upon Isley Brothers' 1954 song of the same name in its entirety. After a trial in which the Bolton defense expert conceded that he had not found the combination of unprotectable elements in the Isley Brothers song and any prior composition, the jury entered a verdict that found infringement based on the new combination. The district court denied the motion for post-motion judgments, and Ninth Circuit affirmed. So Michael Bolton was a dirty infringer, I guess. Next, although it did not squarely address whether the combination of otherwise unprotectable musical elements at issue warrants copyright protection, the Ninth Circuit concerned whether the first measure in plaintiff's song, one of those songs, did not constitute an original protection as a matter of law. Carey advanced this argument for the first time on appeal as alternative basis to affirm the district court's grant of summary judgment. She contended in part the alleged infringed 7-note measure of plaintiff's song lacked protection because of its brevity. That argument makes no sense to me, or it didn't 11 days ago. The Ninth Circuit rejected this argument, explaining that while a single musical note would be too small, an arrangement of a limited number of notes can garner copyright protection. Yep. The court held it cannot be said as a matter of law that 7 notes is too short a length to garner copyright protection. Yeah. The Ninth Circuit again addressed the issue only hypothetically in a prior case. While it's discussed, the court held that a virtually identical step of the analysis did not apply to the musical composition at issue, an entire work just a portion. The court embraced and applied the principle from Apple Computer, Stavet, and Swirsky. The combination of elements there, portions of 6 musical elements, the signature phrase, hooks, bass line, keyboard chords, harmonic structures, and vocal melodies may receive protection if sufficiently original. Yeah, so basically you are now telling me in very long wording that combinations can be protected, which I kind of knew, but now you're explaining to me why. But it's like, yeah, I was already there. I was already there. Combinations can be protected. I was already there. At trial, the jury found the combination of these elements of the gay song, Gotta Give It Up, was protected. The Fix parties infringed on protected elements, returned a verdict to gays and award damages. Yeah, that one was and that decision was wrong. The blurred lines decision, that was wrong. Yeah, that was like too floaty. You know, the infringement was the feel of the song, which, you know, was not enough. It wasn't close enough, in this humble man's opinion, to be infringing. So I thought that case got screwed. Accordingly, the Ninth Circuit's review of the jury finding, a protected combination was confined to a fact-bound, highly differential review that did not permit the panel to revisit the protectability issue, even was able to determine substantial similarity or lack thereof on the instructive test. Which that language strongly suggests to me that these were jury questions and the jury reached a verdict. Are we going to overturn the jury based on the extrinsic test in light of this? I don't know, man. I'm having my doubts as to where this decision is going. Jordan Lewis says it's subjective. Yes, it is subjective. Sometimes law is subjective. That's what juries are for. Which is also one of the reasons that I am a little bit weary of where I think this decision is going. Because one of the things juries get to do is determine facts, because they're often subjective. So we take everything that's available and give it to the jury and tell them to determine the objective reality. And then they do that, and that is now the objective reality. And so they get to consider things like, was this witness telling the truth, and how truthful they were, and were they able to see things? Juries get to consider subjective questions all day long. That's one of the things juries are for. One of the things juries are for is to turn the subjective into the objective. So we take all the subjective and we put it through the machine, and now it's objective. Now that is the facts. Those are the facts. That is now what happened. Shut up. That's reality. So yes, it is very subjective, but that's what juries are for, which is also why I'm saying to myself in the back of my head as I'm reading this. That's why I'm saying, something here doesn't seem like it's going in the right way. Accordingly, yeah. Although neither the district court nor the Ninth Circuit for this reason had opportunity to consider the question of protectability as a matter of law after all evidence had been presented, the court's conclusion the jury could have found 6 individually unprotectable elements identified tried cumulatively protectable is informative. Yes, I would describe it as informative. Yes. I don't know, Jordan. I haven't got that far yet as to make a conclusion as to whether I think the judge is wrong. I haven't gone that far yet. I have used the tea leaves of the storyteller. I've used the tea leaves of the storyteller and used rules of storytelling to project where this is going. And it's I'm concerned about where this is going. Now, I don't know if it's actually going there or not. Maybe there will be a whole lot of things, right? Because we haven't gotten to the end of the story yet. But I'm looking at this and I'm I don't know, man. Some of this seems a little bit, I don't know. It seems like you're saying things that are going to take us into the wrong place. So I haven't concluded whether or not the judge is wrong yet, because we haven't gone that far. We haven't gotten to the end of the story. But in the middle of the story, I'm looking at myself. I'm like, uh-oh. A court in the District of Oregon squarely found a protectable combination of otherwise unprotected musical elements. That case involved 2 musical compositions that transposed the digits of pi to a set of musical notes. Wow. Okay. Developed as a motif. The plaintiff alleged that the defendant's composition infringed in its entirety upon plaintiff's composition in its entirety. Yeah. The defendant moved to dismiss the complaint pursuant to the extrinsic test on the ground that lacked any similarity between an unprotectable idea of putting the digits of pi into music. The court agreed that pi is a non-copyrightable fact, and transcription of pi is a non-transcopyrightable idea, but did not end its analysis there. Pi is in the public domain. Yes, we're very comfortable with the idea that pi is in the public domain, yes. After filtering out these unprotectable elements of allegedly infringing copyright primary motif, the court considered whether the composition's remaining pattern of other musical elements, the choice of scale, rhythm, harmony, and embellishments or variation, comprised a combination of elements protectable pursuant to Apple computers. The court concluded it did. The copyrightability of the song is not the melody based on pi, but the fitting together of the sequence with other melodious phrases in a composition. Again, all this is just telling me that individual elements, even though not protectable, in combination are protectable. And this is also teeing up a potential weak copyright analysis, which I don't think is really appropriate in this situation, but it's also teeing up a weak copyright analysis. So that's another where the point is saying, uh-oh. It's you're teeing up something that I'm not sure you should be doing. So we'll see if you're going to get there, and if you get there, whether or not you change my mind. See, this is one of the many benefits of me reacting to this in real time. Like, I get to read it and share the law and share my understanding of the law, and I get to say, like, I get to highlight in big, massive, like, things. This right here, where they said Led Zeppelin, this right here is a big change of the law. Pay attention to this part, because this is a change of law that's happened over the last 10 days, literally, because this was decided on March 6th. Literally 11 days ago, this was not the law. Now it is. So, like, I could say things like, oh, yeah, okay. But I'm reading this and I'm like, I don't know. We'll see. Other courts have declined to find similar combination of musical elements protectable. In Stefani, for example, I assume that's no doubt Stefani. Okay. In Stefani, for example, a court in the district court considered whether distinctive pronunciation and rhyming, use of a particular lyric at a particular beat, rhythm, recurring vocal phrase, and presence of tritones qualified the planned songs for copyright protection by virtue of the arrangement and original matter. The court concluded these features were not voluminous enough to provide the quantum of originality needed to merit copyright protection and entered a judgment for a matter of law. Wow. Wow, that's slicing it really tough. Cause, like, what is the difference? What is the difference between Stefani and, say, Erickson v. Blake? Especially on a judgment of law standard. On a judgment of law standard, which, again, like, going back to the way we started this discussion originally, when we're talking about judgment as a matter of law, we mean that, taking the facts in a particular posture, is the legal result required? Whether that's at a motion to dismiss or a motion to summary judgment or judgment notwithstanding the verdict, whatever stage it is of the trial, given some factual posture, must the legal result come out a particular way? And the factual posture, to me, between Stefani and this Erickson case is so, like, I don't know that I can split it. I don't know that I can split it in my head, where I'm like, I can clearly put one on one side of the line and clearly put it on the other side of the line. I'm having a difficult time compartmentalizing the two decisions. They're too close to me where I can say, oh yes, this is on one side and this is on the other side. It seems like, I don't know, man. I don't know. It seems more of a factual question than a legal question, but you're saying it's a legal question. And, then judges are doing this. And judges aren't expertise in music. It's not exactly like, the layperson is expertise in music, but they're at least as much an expertise as the judge is. And there's 12 of them. So, let the jury figure it out is my first instinct. Okay. That's weird. That's weird. Maybe as the stream develops, I'll be able to split that in my head and I'll be less confused. But at the moment, I'm like, I don't know that I can split that one. Similarly, in Cottrell versus Spears, Britney, baby, plaintiffs allege that Britney Spears, What You See Is What You Get, infringed upon the following compositional elements of their song, What You See Is What You Get. 2 identical pitches at the opening of each song chorus, 2 verses that begin and end with A minor chord, the repetition of a particular note 3 times in the verses and setting a 4/4 time. That does seem like it's on the other side of the line, but I can't explain to myself why. And when I can't explain to myself why, that is not a good sign either. It's like, yeah, that does feel like it's on the other side of the line, but I don't know that I can explain to myself why. So it just feels like, if I can't explain to myself why, then it's just, like, subjective, right? It's just like, if I can't explain it, I'm just substituting my judgment for the jury's judgment, which always makes me nervous. I like to be able to explain it if I'm going to, like, put one in one category and one in the other. After concluding none of these elements were individually protectable, the court cited the Ninth Circuit standard and considered whether the combination of unprotectable elements may nevertheless qualify for copyright. court then cited Ninth Circuit's decision in Stavia for the rule that elements must be numerous enough and their selection and arrangement original enough to warrant protection. Man, that's such a subjective standard to me. It's such a subjective standard being decided by a judge on effectively a motion to dismiss or a motion for summary judgment, because the court said it was the same standard. So, like, that is such a subjective standard. If they're numerous enough and the selection arrangement original enough to warrant protection, that's so subjective. It's like, and if it was the jury doing it, I wouldn't be so bothered, because that's one of the things that juries do, is take the subjective and make it objective. If the judge was acting as the jury, in other words, if this were a bench trial, then obviously I wouldn't care either. Because if it's a bench trial and the judge is the jury, because it's a bench trial, then sure, the judge is the jury. And so as the jury, they can do that too. But if it's just the judge acting as a judge, I'm like, a lot of this is subjective. And this test is subjective. It feels like, let's let a jury figure it out. That's what they do. I'm like, but you're making this a legal standard. I don't know, man. I don't know, man. Considering these decisions, the court notes as follows. First, Swirsky stands for the proposition that even a very short musical phrase containing some mix of musical elements may be entitled to protection if the mix is sufficiently original. Second, each of these cases addressed and found the protection of combination of otherwise unprotectable elements. The protected combination concerning a mix of compositional elements present across compositional work as a whole, not within a single protection of the composition. And third, the number of elements comprising a given combination does not strictly determine its protectability in aggregate. That's true. It's definitely not the number of them. That would be insane. That would be insane to say it's the number of them. That makes no sense at all. That makes no sense at all to say it would be the number of them that makes it protectable. That's ridiculous. You could have theoretically two elements that by themselves are both in the public domain, which somehow in combination are an original work. Don't ask me to provide an example. I'm just saying it must be theoretically possible. It must be theoretically possible to take two works that are unprotected and in some combination of them put them into a protectable work. And conversely, it must be possible to take 100 works, all of which were unprotected, and put them together in some combination that is not protected. So just because it's 2 doesn't mean that it's unprotected. And just because it's 100 doesn't mean it's protected. That would be insane. That would be insane. It can't be the number. That doesn't make sense. That doesn't make sense. It has to be based on the qualia of it, which again makes it subjective, which seems more of a jury issue. But okay, right? My field is patent law. My field is patent law, so I deal with this all the time. I deal with this all the time in patent law when it comes to obviousness and prior art. All right. So, in patent law, we have this exact thing happen all the time, right? If I'm trying to find, if I'm looking at an application and I have 2 things of prior art, right? Those 2 things in prior art may be enough, and 10 things of prior art may not be enough. It's a qualia based determination, but yeah, okay. I don't know, man. This is, oof. I don't know. Oof. In view of these decisions, the court now turns to whether the musical arrangements that comprise the 8-note Asana and Joyful Noise are numerous enough and arranged in sufficiently original manner to warrant copyright protection. Okay, well, the rubber is about to meet the road, guys. The rubber is about to meet the road. We have set up the predicate. We have set up the predicate, and now we have to do the analysis, right? So we have successfully designated the issue. We have successfully illustrated all the rules that apply. This will sound familiar to law students everywhere, right? And now we're going to do our analysis. We have spent the first 20 pages doing I and R of the IRAC method. We have spent the first 20 of 32 pages doing I and R of IRAC. We did our issue. We did our rule. Now we're going to do the analysis. Now we're going to take all that and like put it together, and does it make sense? Let's see if the court can convince me. I mean, I'm not closed-minded. I'm not closed-minded, and I haven't even gone to the end of the story. All I have been saying so far is uh-oh. But maybe they'll put it together in a way that's like, oh, okay, I'm on board with this. So let's find out if I'm on board with this. This will be good. Yeah. What is the chances of appeal? I'll get back to you when I get to the end of the decision. You know, it depends how good I think the decision, I guess, is, at least in part. I'll get back to you. In view of these decisions, the court now turns to whether the musical elements that compromise the 8-note ostinato and joyful noise are numerous enough and arranged in sufficiently original manner to warrant copyright protection. The court concludes they do not. Okay. Although Swirsky contemplates the possibility that 8-note musical phrase may be entitled to copyright protection pursuant to Stavia, the parties have not cited any authority, let alone binding authority, hold that an otherwise unprotected musical phrase, isolated from the rest of the musical composition, in fact warranted copyright protection. The parties have not cited any authority, let alone binding authority, holding that an otherwise unprotected musical phrase, isolated from the musical composition, in fact warranted copyright protection. You are assuming the phrase is uncopyrightable. That's where I'm having or unprotected, to use it another way, which is exactly the same thing, right? Unprotected or uncopyrightable would be saying the same thing. All right, so the court says, although Swirsky contemplates the possibility 8-notes may be entitled to copyright protection, parties have not cited any authority holding an otherwise unprotected musical phrase. Well, you're kind of begging the question, right? Because you have this case Swirsky that says an 8-note this case Swirsky that says an 8-note musical phrase may be entitled to copyright protection. So a short phrase can be copyrighted. And then you have this, and there's no authority holding the otherwise unprotected phrase is in fact warranted copyright protection, which I suppose makes sense. If the phrase is isolated, is not entitled to protection, then okay. But you're assuming your premise. Hopefully you're going to justify it somewhere along the line. Because if you don't justify it along the line, it's like, you've begged the question. You beg the question, is this phrase protected or not? So I hope you're going to show your work a little bit on that one. C. Nimmer. It is most unusual for an infringement to be found on basis of similarity of a singular line. And generally, the likelihood of copying but a single line of such importance as to warranting a finding substantial similarity is remote. I suppose it depends how long the work as a whole is. You know, there's, what is that Emerson poem where it's like, a for sale, baby shoes never worn. End. I mean, the entire story is six words long. I mean, I think the intellectual property community at large agrees that that's copyrightable, despite it being 6 words. So, like, you know, I suppose it depends how long the work is. And how's that work in music, and how's that work in sampling of music in particular, is another phrase. Like, okay, so it's like, because there are people who do sampling of music and take lots of pieces from lots of different music. So is the court, I guess the court is saying, and it kind of makes sense, the court is saying that if I copied a sentence from 1,000 different books, then it would be non-protectable. Because, like, well, for starters, how do you know they came from those books in particular would be another issue. But in music, it's a little bit easier, especially in sampling. So, like, is the court now basically implying that all sampling is now constitutional or legal or not protected by the Copyright Act? It is undisputed in this case, even viewing the evidence in the light most favorable to plaintiff, that the signature elements of the 8-note ostinato and joyful news, the 3-3-3-3-2-2 pitch sequence, resolution sequence with 3-2-1-5 sequence, the even rhythm without syncopation, development across a space sparse texture. I'm not sure what makes it sparse in particular. I mean, they're quarter notes. So there's as sparse as quarter notes would be at a particular BPM. That's how quarter notes sound at that particular BPM. I'm not sure what you mean by sparse. Okay. It's not a particularly rare or unique or rare combination. Even its development as an ostinato. No. No, I can't agree with that. I cannot agree with that. I think not only is it not undisputed, I think that is, in fact, the dispute. That is, in fact, the dispute. So, like, to say it is undisputed in this case, no, it's not undisputed. It is extremely disputed. That is at this point, the central aspect of the dispute. That is the dispute. That is the entirety of the dispute at this point, basically. The court says it is undisputed, and I'm like, no, it's not undisputed. That is, in fact, the exact dispute. That is exactly 100% the dispute. That is exactly what's going on. It is disputed in this case. Viewing the evidence, light most favorable, that the signature elements, blah, 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 and then it says, is not a particularly unique or rare combination. That's the dispute, man. That is the dispute. No, that is the dispute. Whether it's a unique or rare combination. In combination. It is undisputed. It is undisputed that them in isolation is not unique or rare. That is not disputed. That is not in isolation. But we're not talking about isolation. We're talking about combination. So this sentence just seems plain wrong. It just seems wrong. That it's undisputed in this case. That is not a particularly unique or rare combination. I mean, that is the entire dispute. That is the dispute. What are you talking about, court? What are you talking about? $5 Canadian from S.J. Jarbanks, whatever. Your views on the newly enacted anti-hoarding gouging estates. I don't believe it's newly enacted. It may be being newly enforced, but anti-gouging, anti-hoarding laws, well, anti-gouging in particular, has been on the books for a long time. That's not new. Do you think the cases will survive qualified immunity? It's not a qualified immunity issue. I think it will survive a legal challenge, to get to more to the point. And increased CAF, which I have no idea what that means, to be honest, by the police, which I assume means something of force. But yeah, I think the regulations dealing with anti-hoarding, anti-gouging are probably constitutional, as well as a lot of the restrictions they're talking about now, because, like, here's your very, very short constitutional analysis on the measures that are being taken that are restricting people, right? So people are like, oh, because, like, they're saying no gatherings of more than 10 people, including, for example, religious services, so that would also include, like, protests outside, like, capitals. It's like, wait a second, well, doesn't that infringe the First Amendment? Well, here's your very, very simple First Amendment analysis on all that stuff. Very simple. Okay. First Amendment the regulations are protected. The regulations are permissible under the First Amendment if they pass strict scrutiny. To pass strict scrutiny, they have to be a compelling governmental interest, and it has to be the least restricted means. So here's your question. Does the government prohibiting people from gathering in groups or going to bars or, like, going to religious services or whatever, does the government have a compelling governmental interest, and is the restricting of people from gathering in those the least restrictive means? I don't think the idea that the government will be able to pass strict scrutiny is beyond the pale. Normally, passing strict scrutiny is impossible. But, in this situation, I think their ability to pass strict scrutiny looks a little bit better. So, I wouldn't necessarily say any of these regulations are blatantly unconstitutional on the face of it. because I'd actually have to do the strict scrutiny analysis. I'd actually have to think about it, which normally I don't have to think about it at all, because to say this passed strict scrutiny is so dumb in almost every situation. It's like you don't even have to do it. But here I'd actually have to do the analysis. So yeah, there's your short answer for the day. By the way, just for the record, so that I'm not misunderstood later, I'm not telling you that this is good. I'm just telling you what the law is. So I'm not saying it's good that, First, Fourth, Fifth, Sixth, Eighth Amendment rights are potentially being compromised. I am telling you that their ability to be compromised is going to be subject to a strict scrutiny analysis, and the test for strict scrutiny is compelling governmental interest in the least restrictive means. And, we'd actually have to think about it. So I'm not saying it's good, I'm just telling you what it is. Don't blame the messenger. Prior compositions, including prior works composed by the parties, as well as what all agree is a separate, non-infringing sonata, all contain similar elements. Judge Hand? Are we quoting Learned Hand? Anytime we're quoting Learned Hand is great. If I see Judge Hand, I assume we mean Learned Hand. Learned Hand is kick-ass. Court also notes Judge Hand's observations made nearly a century ago. That would be Learned Hand, yeah. Made nearly a century ago that Ain't No Asinota was a proper subject of an infringement action since it comprised a substantial component. Well, if Learned Hand said it, I believe it, man. Learned Hand was one of the great ones. That these other works may also contain other dissimilar elements does not alter the conclusion that the elements they share in combination comprise a bedrock of what plaintiffs and their experts claim to be original. That does not meet the appreciable standard of originality. All right, I feel like to me, it's what I would consider conclusory. It's conclusory. We spent. Where are we on this thing? We're on page 21 now. So okay, we spent the first 20 pages of this thing setting up the issue and setting up the rule. Right? We set up the issue and set up the rule. That was 20 pages it took us to set up the issue and set up the rule. Now we're in the analysis section, and the analysis section is basically over in a page. It's basically like, oh, in combination, they're not protectable. And I'm like, why? Why not? And we've kind of moved on to the conclusion. I'm like, it leaves a little bit something to be desired. You ever see that, I think it's Far Side cartoon, where it says like, where it has someone's drawing a math equation. Like step 1 is this like really fancy like math equation, and step 2 is then a miracle occurs, and step 3 is like more math equation. And the guy says, I think you need more in step 2. That's kind of how I feel about this. I feel like you skipped over the analysis there a little bit. You set up so much time on the issue and the rule, you skipped over the analysis. You're treating this very conclusory. It's like, okay, first of all, you say it's undisputed, and then like it's also in a similar work, and then you say the other works may also contain dissimilar elements, does not alter the conclusion. The conclusion, where's the analysis? Does alter the conclusion that they share in combination a bedrock of what they claim to be original. Does anyone actually see any analysis of any kind in this case? I mean, we skipped right from issue rule right to conclusion. Where's like the analysis? I suppose the entirety of the analysis is baked into the 3 words, it is undisputed. Okay, well, the entirety of the analysis is baked into the words, it is undisputed. Which, in this humble lawyer's opinion, is like, no, it is very, very much disputed. It is, in fact, the heart of the dispute. So apparently the entirety of the analysis is, it is undisputed. So the entirety of the analysis is, a miracle occurred. I'm not really feeling that one personally. I'm feeling it's a little bit thin here. on the analysis, a little bit like you're taking as given. It's begging the question. It's tautological. You have assumed the very premise that you have to reach. Okay. I have my doubts. I have my serious doubts here. Yeah, so it's undisputed. Okay, prior compositions, including prior, all agree, as well as what all agree are separate, non-infringing ostinatos. Well, it's non-infringing, so who cares? It's not infringing, so it doesn't matter. All contain similar elements. And we're back as OBS froze on me once again. I guess OBS objects to what I'm saying, so whatever. Let's get back to where we were, but I'm not really buying any of this stuff. Okay. That the work may also contain other dissimilar elements does not alter conclusion. The elements may share in combination comprise a bedrock of what they claim to be original. I think that is in fact a dispute. This does not meet an acceptable standard of originality. It seems a little bit conclusory to me. The other 8 elements present in plaintiff's 8-note ostinato also do not bring the combination with the ambient. The placement of the ostinato within the composer's composition verses do not make it so exceptional as to warrant protection. Well, that's an easier principle to defend. Given the earlier conclusion, but the earlier conclusion is still like whatever. So like, just so like you understand like the two parts of what's happening here, in case it wasn't clear. In part 1, they were trying to determine whether this ostinato thing is protected unto itself. And in order to determine that, hypothetically, you'd want to look at like the combination of all the things to try and determine whether it was. So we spent 20 pages doing issue rule, then just said it's true, and we went on. Okay. All right. So the ostinato by itself is not protected. So now the court is going to analyze the question, well, given that it's not protected, is its combination in line with the rest of the music protected? Well, if you want to say no to that, I'm going to have a much easier time than that. But, because, okay, I'll buy that. But, like, the underlying premise is... The placement of the ostinato within the composition's verses do not make it so exceptionally original as to warrant protection. Finding no legal authority for the court to consider the location of a single common 3-note sequence in a musical composition is sufficient to support protectability in the context of alleged infringement. Fine. That the ostinato is placed in the minor scale does not make the combination sufficiently original given the limited number of scales that exist. I feel like the court is flubbing the analysis here. I don't think there's literally anyone who's arguing that because it's in the minor scale, it's protectable. That's not the issue. The issue is the combination of all the things. So. See Led Zeppelin, the new case, holding that musical concerts like minor chromatic line associated chords have been used in music for quite a long time as building blocks. Yeah, as building blocks. No one is arguing the building blocks are protectable. We're talking about the wall. Is the wall protected? That's what we want to know the answer to. That effectively leads to the ostinato-piggy synthesizer sound, which, even if it's considered a function composition, would not transform it into a protected expression. I feel like you're looking at these things in isolation rather than combination. I feel like I feel like you're doing exactly what you're not supposed to do. I feel like you're looking at each of these elements in isolation, and you're saying, well, each of these elements are not in and then I can dismiss them one at a time, right? I can look at them one at a time and dismiss them one at a time. Well, you can't do that though. That's the problem. You can't do what you're doing. You can't do that. You have to look at them in a total combination to it, and you're doing this more in isolation. So your analysis seems off. Synthetic timber, as mentioned above, is a common element. No one is arguing that. That's not the issue. Relatively common 8-note combination of unprotected elements that happens to play timber in combination to a particular genre cannot be so original as to warrant copyright protection. No one is arguing that. No one is arguing that. No one disagrees with you. That's not the issue. No one is arguing the 8-note that happens to be in timber combination to the genre warrants copyright. That's not the issue. That's not the issue. There's more than that. There's more things than that. You're ignoring. Because the sole musical phrase the plaintiff claims infringement upon is not protectable expression, the extrinsic test is satisfied and plaintiff's infringement claim, even with the evidence construed in plaintiff's favor, fails as a matter of law. A plaintiff who cannot satisfy the extrinsic test necessarily cannot prevail on a matter of law. Well, that part's true. Defendant therefore entitled to judgment as a matter of law on plaintiff's copyright claim. Conditionally and alternative, defense are entitled to a new trial because the verdict is against clear weight. I don't know that I can agree with either one of those. No. So yes, we've gone to the end of the story. We've gone to the end of the story, and my uh-ohs from earlier in the story where I was like, this seems to be heading in the wrong place, have indeed led us to the wrong place. I don't think I can agree with this decision. The analysis is wrong. I think the court properly stated the issue. I think the court properly stated the rules. And I think the court completely blew by, and to the extent they mentioned it at all, did the analysis section wrong, and therefore the conclusion is wrong. That's what I think. They just didn't do the analysis. Now, I'm not even 100% sure that you can't do the analysis and come out the same way. So maybe if you did the analysis, I'm not even sure how you go about doing that. But even if you did the analysis, maybe you'd come out this way. But the court didn't do it. So I feel like they just skipped like a step and went to the end of the page, and I'm not following. Normally I don't really mind going to the end of the page because it saves time. By end of the page, I mean like we just skip a whole bunch of crap that isn't necessary. But at least to me, it's like, well, to me this is like, it's more nuanced than that. It requires more. So I'm not a fan of like being verbose when there's not a need for verbosity. I've read many a court decision where I'm like, this could be resolved in like 3 pages. Because like, do I really need to go through everything? No, I really don't. But here it's like, okay, I kind of need to go through everything. And here it just feels, So, I don't know if you can get anywhere on appeal. I don't know if you can get anywhere on appeal or not, but I figure your odds of appealing are better than they would normally be. This seems a problem. Even if the S8-note Asano were protected, defendants would still be entitled to a judgment of matter loss if evidence submitted at trial does not support a legal conclusion that they are substantially similar. Well, that does seem, again, like a factual question to which a jury has already said they are. That is kind of a necessary part of the jury's verdict, that they were, in fact, substantially similar. So, like, who are you to do this? A selection and arrangement is infringed only where the works share in substantial amounts of particularity the same combination of protectable elements. Here, because the range of protectable elements in the A-pop music Asano is narrow, the combination of unprotectable elements the defendant's alleged infringing Asano would necessarily have been virtually identical in order to substantially similar. Okay, well that analysis is more defensible. That analysis is more defensible. So we've gone from the concept of there's no protection to there's thin protection, and because there is enough difference, therefore they can't be found in infringement. That's a more defensible analysis than what we saw before. That this is, because of its nature, a thin copyright, and only like truly identical or near identical in these pieces, although substantially similar, at least in my ear, is not, if it's narrow, is not virtually identical. So, given that premise, that's a lot more defensible than what we saw before. But again, I feel like that's more of a jury issue. And so like you wouldn't give them, because when you look to the substantial weight, the court said this earlier themselves, when you're looking to like substantial weight and you feel like it's wrong, you feel like the jury verdict's wrong because it goes against substantial weight, you don't issue judgment as a matter of law, you issue a new trial. So this is the wrong remedy. This is the wrong legal remedy. If the issue is that the evidence does not support substantial similarity, it seems more of a, While virtual identity is not the same as absolute identity, of greater distinctions, the existence of greater distinctions do indeed negate liability. For example, Erickson found no infringement where the cadence flourishes harmonies and structures, or other elements of defendant's song were not virtually identical or even particularly similar to Plante's thinly protected composition. This is a lot more defensible. I'm not having quite the same reaction as to the other one. Like, this seems like more defensible. I'm not sure if I necessarily agree, but at least it's defensible. The evidence in this case does not support a conclusion that relevant ostinatos and darkful noise and joyful news are virtually identical. There are a number of undisputed objective distinctions that, as a matter of law, negate liability. First, Dr. Decker testified the pitches on the 7th and 8th beat of ostinato are different from the pitches of the corresponding beat. In joyful noise, the pitch sequence on the beats resolves up from B to A to F, while in dark noise, the pitches on the sequence resolves from A to E. Plante characterizes this testimony as signaling the similarity in how the songs resolve. He points to Dr. Decker's testimony that both ostinatos share similar musical strategies for how to end. But that conclusion is contrary to law. The question of whether the identified and allegedly protected concrete elements of joyful news ostinato are in their combined form objectively similar in articulable ways to corresponding concrete elements, not to whether the ostinatos reflect common strategies. That is right. That I agree with. And that also is like a parallel rationale to why I thought the blurred lines decision was wrong. Because like the strategy is like, that is much more legally correct. That is fine. The fact that two-note ostinatos resolve using two different pitches, despite a tendency to resolve with only a narrow range of pitches, indicates objective distinction rather than similarity. Okay. Second, the composition for the ostinato and joyful noise includes at least 6 instances of portmanteau, a slide between musical notes not present in Dark Horse. Okay. Dr. Decker testified he does not hear these differences as significant, but that opinion is largely irrelevant. I feel like this is a little relevant. Dr. Decker acknowledged the presence of the slides of competition for joyful noise as a difference between the compositions. And third, Dr. Decker acknowledged the compositions for ostinatos use different keys, tempos, harmonies, and rhythms. Okay, this I'm buying. This I'm buying a lot more. This I'm buying a lot more than the first part where it's like, oh, it's just not protectable. I'm like, But this, like, okay, we're going to say it's a thin copyright, and as a result, here's some differences, and the differences are enough to not be within the thin copyright. Okay, this part I can get behind. So maybe I don't have to, like, destroy if I'm the Court of Appeals, I'm going to adopt this logic and ignore the other logic. Because that's one of the things in the Court of Appeals I get to do. It's nice. It's a nice job perk. I get to, like, take the part that, like, makes your decision right and ignore the rest. So I'll just take this and ignore the rest. So that's not so bad. Taken together, the objective distinctions are substantial enough to preclude a determination. For this reason, even if joyful noise ostinato were entitled to copyright combination in the aggregate, and the court concludes it's not, which is a conclusion I question at best. And in fact, I think it's just wrong, to be quite honest. The court concludes the defendants would still be entitled to a judgment as a matter of law. Defendants are therefore entitled to judgment as a matter of plaintiff's copyright claim conditionally, and the alternative. Defendants are also entitled to a new trial because of the same reasons. Jury's verdict is against clear weight. Yeah, I don't know if it should be a directed verdict or a new trial. Given the legal standards that we recited earlier, a new trial seems like the better remedy than a directed verdict. But I don't agree that they're unprotected. The degree to which, but these are more like legal. These are more like factual questions, right? Mm. So sending it back to a jury for another go is more rational. Defendant also moves for judgment as a matter of law on substantial similarity pursuant to the intrinsic test. The intrinsic test is subjective and asks where an ordinary reasonable person would find the total concept and feel to be substantially similar. These subjective questions, whether the works are intrinsically similar, must be left to the jury. Since the intrinsic test for expression is uniquely suited to determination by trier of fact, reviewing courts will not second guess the jury. Although some district courts have determined the intrinsic test can be resolved as a matter of law, where no reasonable person could confuse the concept and feel, the court declines to do so here. Even though the court concludes the plaintiff's asana is neither protected nor virtually identical, a reasonable jury could nevertheless conclude the concept and feel are intrinsically similar. Defendant contends that they are entitled to judgment in matter of law because no supporting finds access. A trial plaintiff relied on a theory of widespread dissemination to prove access. The question presented by the post-trial motion is not whether the plaintiff has proven access, but whether reasonable minds could find a reasonable opportunity. Given the unique ways media arises online, access may be established by trivial showing. Courts must defer to jury's determination. While distinguishing a bare possibility from a reasonable possibility present a close question, the court believes the evidence presented at trial was sufficient to find as to access. Plaintiff present evidence that was played more than 6 million times on YouTube and Music's MySpace, and Joyful News was nominated for a Grammy. Joyful Noise was performed at hundreds of concerts. Joyful Noise was ranked highly on Billboard charts. Reasonable jury could conclude that a reasonable opportunity to encounter. All right. So, yeah, okay. Then we got, I'll just skim through the other defenses and won't read them verbatim because we got the main law that we want. Right. Okay. So we got independent access, which is when they come up with it independently. Okay, and then it says, yeah, so it was a jury trial they failed to establish ownership as joint work, liability defenses, damages issues, failure to deduct overhead, which is very technical in terms of money, motion for new trial. Had the court not granted defendant's judgment as a matter, the court would have exercised discretion or a new trial. The jury damages award, which disregarded powerful testimony that was Kay's star power and Capitol Records marketing error generate commercial success, seems clearly against the way of the evidence, if otherwise based on substantial evidence. How the court reached the error, the court would have been inclined to order a new trial unless murder was accepted. Prejudgment interest and conclusion. All right, so that's the end of that. All right, so I have some serious questions and serious doubts with this decision against Joyful Noise. I think the copyright analysis as to whether there is copyright is wrong, or if it's right, it's not well explained at all. It's not persuasive to me. I think the analysis as to why it's thin is probably better, although why it's thin is probably better. An explanation, and also the remitter on jury damages also seems more plausible. So there's some of this I agree with, some of it I disagree with, but the end conclusion is that Katy Perry will not have to pay her $2.8 million today. Whether or not what's his name wants to appeal this or not, Flame wants to appeal this or not to Ninth Circuit, only time will tell. I think he's got some pretty plausible arguments here So we'll see what happens next. But for the people who were here and watched this stream, I hope you liked it. Until later, my friends. Cheers and goodbye.